thank you for being here today and for your patience. I disagree with the bitter end phraseology that was used. I think the entire conversation has been extraordinarily interesting, and I appreciate your being here to share your thoughts. I'll set this up with a standard question. Do you agree with the following statement from former Commissioner Wilson? The agency lacks the expertise and in some cases the jurisdiction to pursue the additional societal goals embodied in the strategic plan. And jumping just to the phrase unwarranted health, safety, and privacy risks. I'm actually looking at the plan right now. For example, unwarranted health, safety, and privacy risks. Tell me how those became part of the focus of the FTC, because that seems to be an expansion of what the FTC used to focus on. Or maybe I'm wrong, but that's not my question to set up, my first one.
So I think you said unwarranted safety, health, and privacy risks, is that right?
Yeah, actually, I'm just reading from the FTC focuses on investigating and litigating conduct that causes or is likely to cause substantial injury to the public. This includes not only monetary injury, but also, for example, unwarranted health, safety, and privacy risks.
So the statute says that an unfair practice is one that causes, one of the prongs is substantial injury. Substantial injury is not defined, but for years now, the FTC has interpreted that, and courts have ratified that to mean not just monetary harm, not just losing money, but certain types of harm to wellness and safety and health. So some of the deceptive advertising cases.
Are you referring to courts? Is that what you said?
That's right. And
okay, so just because I want to move on,
sure.
If you could provide me with the cases that you're referring to, please, so that I can see the courts that you're relying upon for that effort. Now, let me slide that aside and let me go to the next issue. This is one, of course, that you brought up in your famous paper, the Amazon antitrust paradox. And the issue is, and forgive me, I'm not an expert in this space. I didn't even take this class in law school. So my question, antitrust. So my question is, what if not the consumer welfare standard? What standard? And I'm basically lifting this right out of Bork's book, about 25 hours I'll never get back, that I spent reading it. And my question to you is, if not that standard, what standard are you going to apply? Or do you still apply just that sole standard in determining the challenges that bigness creates?
So we applied the text of the statutes that Congress passed, and we look closely at the language in the statutes that Congress passed, consistent with legal precedent. There are some case holdings related.
If I may,
yeah.
If I recall correctly, before Bork's learned treatise, there was a mishmash of legal precedent. You could select among almost any standard. That's one of the reasons he was so clear in stating what he thought would be the proper standard, and that is the best for the consumer. So I'm asking you, if you're going to move away from that standard, which he so artfully articulates in his book, what is the new standard?
So we're focused on the law, including the case law.
Wait. I just pointed out that before Bork, there was any number of standards. Just grab one. So when you say you're looking at the law, which law?
The Sherman Act, the Clayton Act, the FTC Act,
so those
the
are extraordinarily. They were written to be very broad and to give you the power to try to control this economy that we've got. Bork went in and tried to find some sort of a standard against which you could measure your actions. And his ideas were accepted. I think your article, you know this way better than anybody in this room. So my question is, what's the new standard? Please don't take me into the law, and don't do that. Tell me what do you have that's better than what Bork suggested?
So in instances where the Supreme Court has said, for example, that the Sherman Act should be interpreted consistent with consumer welfare, of course we look closely at that. But the Sherman Act is not the only statute, right? For the FTC, we're charged with prohibiting unfair methods of competition. And I think it's incredibly important for us to honor Congress's intent in creating multiple...
Wait, stop. You're a lot of generalizations. What's the standard that you are suggesting to take the place of the consumer welfare? What's your standard? Please don't give me generalizations.
So the standard depends on the statute that we're enforcing, because each statutory scheme is slightly different. When we're enforcing the FTC Act, the words of the FTC Act are unfair methods of competition. That's the standard we're enforcing. We laid out a policy statement last year that laid out in very clear, in great detail what that standard means. reflecting a century of case law.
So I'm out of time, but I will look at your explanation, and I appreciate your time here today. Thank you.